international law norms. They were looking at what constituted an unfair trade practice under international law, and we had treatises after treatises after treatises about what were the international law norms that applied to this case. It was at that point that something began to gnaw at me that bothered me a great deal and still does. I realized the different constituency that a NAFTA panel plays to, as opposed, a US judicial panel. Now this may sound crass, but judicial panels do play to constituencies even though they have jobs for life, as federal judges do, and even though they take seriously their independent role. Nevertheless, judges don't have that much self-confidence that they can go on forever coming down with judgments without worrying about, at least a little bit, what the constituency is. And as far as I'm concerned, a federal judge and a judge of the High Court in the States has appropriate constituencies. He or she worries about what the law schools are going to say about their judgments. He or she worries about what Congress is going to say if they go too far afield. He or she worries about what the next higher court is going to say. I was an intermediate appellate judge, and I always had my eye peeled on what these 9 bosses were saying down the road from me about some of the things that we were doing, he's referring to the US Supreme Court. An international arbitration panel doesn't have any of these constituencies. Their constituencies are this amorphous group of international law specialists, these international law experts. I confess I don't know all of them, but my colleagues would tell me about old so-and-so, who would think this was dreadful if we did so-and-so, and so-and-so, who would have no sympathy for an opinion that did so-and-so. I realized they were looking to a constituent body, a constituency that I knew nothing about. I'm not sure it was one that Congress knew anything about when it set up this arbitration procedure. And for these and other reasons, Judge Mikva concluded that if he had known at the time in Congress what he had learned later from the Lowen case, he would have opposed NAFTA. Now, there are many answers to Judge Mikva's criticisms, but that's not the point. The point is that a senior jurist has made these criticisms in good faith, with an abundance of professional experience as a senior lawyer in his own country, a significant actor in the practice of negotiating treaties, including provisions for ISDS. How can we, as members of this amorphous group of specialists, hope to persuade him, or indeed the farmers in Wallonia, that ISDS arbitrators do have a legitimate constituency with effective academic in public scrutiny? If that was difficult in 2004, when Judge Mikva denounced NAFTA, it seems much more difficult today, if not impossible. Now, would it be different with a new International Investment Appellate Court? As a permanent international court, with senior judges appointed by an international body under a multilateral treaty, I think it would be. And so as to this box, legitimacy, I would put a large tick and not a cross. So in conclusion, I suggest we should all welcome and work with the initiative of the European Commission. It will take much effort, thought, time and goodwill to bring into existence a multilateral international investment court. In the meantime, we could and should help accelerate the least difficult part of this initiative, a permanent multilateral appellate court designed along the lines of the Antitrust Transparency Convention. This new convention should be negotiated by and between states, preferably at the level of the World Bank. The appellate court should be an established international court, as Professor Van Houten suggested years ago, so it should ideally be the International Court of Justice. But if that cannot be so, there is an equivalent, an equally respected candidate in the form of the Permanent Court of Arbitration of The Hague. Now, of course, there are many technical details to go through. Appeals to the appellate court should be limited to issues of treaty interpretation and international law, as well as the grounds listed in Article 52 of the ICSI Convention. It should not be appealed on any issues of fact, whether manifest, serious, or general. And it should be annealed subject to procedural conditions, including permission to appeal by the appellate court, and subject to such permission, the possible provision of security for the amount of the award, be it damages and or costs. And the appellate court should have advocates general, along with good experience enjoyed by the European Court of Justice in Luxembourg. And the court should also permit dissenting opinions as a check on the consistency and integrity of the appellate decisions, as also taking the example from the ICJ. And there should be no system, no formal system of binding precedent. But all this assumes that after January we shall have an international legal order. And as to that, I stop. Thank you for listening.
Thank you very much, John EFILA. I think it was excellent, and it ended with a positive note.